I'm really excited to bring this video to you today because we've got Heath Philips, the attorney, coming to talk to us about foreclosure law. This is going to help you a lot in your real estate business. So without further ado, I'm going to bring us right into the video.
So this is the third time that I've given this presentation this week, so you guys get the very best one. I see some people, Caitlin, Roger and Nathan, Jennifer, were in previous presentations, so thank you for coming out to another one. So a little bit about me. So I'm a managing partner of Heath Philips Law. We are a corporate transactional law firm primarily. We work with small to mid-sized companies and essentially act as outside general counsel for them. So whatever legal needs come through the door, that's what we take care of. Prior to having my own law firm, I was in-house counsel for a number of different companies, ranging from software, technology, agriculture, and so learned a lot there. I'm a 16-year investor with my wife, Margaret. We've been investing in real estate for 16 years now. Primarily, we do buy and holds, try and generate long-term rental income, considering a 1031 exchange. So, Aaron, you're on my list. So that we've been doing it for a long time, primarily residential, multifamily, and single family there. So licensed real estate broker primarily is a value add for my clients, not necessarily listing a bunch of properties, but if anybody has anything to list, I'll do that too. My real estate practice consists mostly of specialty contracts. So if there's a contract that you need that's not on the Dora website, then I can draft that for you in specialized transactions. Evictions, foreclosures, obviously, quiet title actions, anything, and I've been doing a lot of mechanics liens lately, so which kind of ties into foreclosures as well. All right, so I am an attorney, so I have to throw out the legal disclaimer. I apologize for that. Basically, this presentation is not legal advice, so if you have something specific, hire a lawyer, preferably me. All right, so here's what we're going to be talking about. First, I'll kind of cover where foreclosure comes into play, so the situations where it's most relevant. We'll talk about the foreclosure process, and this is a very, very quick and dirty kind of a overview of the process. I've talked to attorneys who specialize just in foreclosures, and even they get stumped on a lot of things, so it's a very complicated field of law and not to be taken lightly. Where the opportunities are, I mean, that's why you're all here, is where you can use foreclosures to grow your business, add investments to your portfolio. Crucial considerations. So one of the things that I hope everybody gets out of this presentation is one or two items to look out for if you're thinking about buying investments in the foreclosure process. Again, very complicated, and there's some gotchas out there, so hopefully you can pick up a couple of nuggets and not make those mistakes. And then just one slide on what I call strategies for success, mainly revolves around doing your homework. I put this quote in most of my presentations, even when I'm doing presentations for corporate clients or potential corporate clients. General George Patton said, "Take calculated risks," and that is quite different from being rash. So we're all in this business, in whatever business we're in. Taking risks is part of what we do every day. But if we do our homework, make sure we know what we're doing, get some mentors, get some experts, build a network, then we can mitigate a lot of those risks and make it a successful project. So, situations where foreclosures are applicable. Essentially, it's a default on any kind of debt or note that's secured with real property. So you think of the primary first mortgage or a deed of trust in the state of Colorado. Second mortgages, HOA assessments, surprisingly, can be liened on the property. Mechanics liens for people in the trades. If they're doing roofing or work, on the property, they can file a lien on the property. Any other types of liens. So there's judgment liens, there's tax liens. Anything that is secured to a specific piece of property can be foreclosed. So the foreclosure process. Colorado is unique. There's actually two types of foreclosure processes in Colorado. One is what's called the public trustee foreclosure, which is the most common and the one used primarily for residential deeds of trust. No other state in the whole country has the public trustee foreclosure process, so we are lucky in that sense. Although if you get into the process, you may not think you're so lucky. But essentially, the public trustee foreclosure, each county appoints a public trustee to oversee the foreclosures in their county. What that does is it keeps it off the court dockets, so you're not subject to court schedules. You don't. The time to get through the process is a lot quicker. It's a lot simpler, and the legal fees are a lot less. So that's why we're lucky to have the public trustee foreclosure. We also have judicial foreclosures. So judicial foreclosures is what everybody else in the country has, and it's essentially exactly like a lawsuit, except it's a foreclosure. So they file a complaint, the homeowner or debtor files an answer, the judge goes through the facts and makes a decision of which party prevails. So, and for HOA assessment liens, mechanics liens, those are pretty much in the judicial process. So the public trustee foreclosure process, all of these start with some sort of a notice. You're always required to give the homeowner or the debtor notice prior to starting the foreclosure process, and that's just to make sure that they're aware of what's going on. We'll see in the judicial foreclosure process, it's almost the exact same thing as a lawsuit. Nobody can file a lawsuit against you without letting you know that you're being sued. So very similar. The next thing that the plaintiff does or the creditor does, the foreclosing party, is they have to submit a document packet to the public trustee. The primary document in that packet is called a Notice of Election and Demand, or an NED, which lists all of the pertinent information. So what property is being foreclosed, who is the foreclosing party, who is the debtor, how much is the default. All of those crucial informations are in the NED. And I just threw up a link there. The Jefferson County website actually publishes on a weekly basis NEDs that have been filed with the public trustee. So that's a good source of, if you're thinking about buying a foreclosure property, then you can keep an eye on these NEDs and kind of get them in your pipeline and keep an eye on how these foreclosures progress. And it might be a good opportunity. So some of the other documents, evidence of debt, promissory note, deed of trust, combined notice and mailing list. So this is another document that's typically published by either the county clerk and recorder or the public trustee. And the combined notice basically has all of the parties involved. So you're going to see if there's a primary mortgage, if there's a second mortgage, then those will typically be on the combined notice. So that's also a very good source of information, because if you're thinking about investing in a foreclosed property, or even prior to foreclosure, bidding on a foreclosure, you're going to want to know all of the parties that have a potential interest in this property. Now, I will caveat that statement by saying the foreclosing property is not required to give notice to any junior liens. So you're probably all familiar with how loans or deeds of trust work on properties, but there's a priority list. So deeds of trust are always first position. They insist on that, otherwise they don't give you the loan. But you can have a second mortgage, you can have an HOA assessment, you can have a tax liens are always superior to everything if they're property tax liens. You can have judgment liens, but there's a priority list. So first deed of trust is always first priority. We'll talk about HOA assessments later, but there's a caveat to that as well. And then everything else is basically first in time. So whatever's filed after that, in order of when those liens are filed, that's the priority. Does that make sense? So the combined notice, as I mentioned, has to be published. So the public trustee is going to publish that for 5 consecutive weeks in a local publication. Typically, they're not the large, well-known newspapers. because those newspapers decided 10 or 15 years ago that they want to make a lot more money on these notices, and so consequently the smaller newspapers usually get these notices. So another good source of information if you're trying to look for a foreclosure property is look in the newspaper, look for these combined notices to be published. And then comes the sheriff's auction. So, and these are also listed on the county sheriff's website. The Jeffco one is up there, and then the Denver County actually has a really, really nice website where they publish copies of bids by the foreclosing party, the schedule and which properties are on the auction list, as well as the NEDs. So Denver does a really nice job. Some of the other counties you kind of have to hunt for this information, but Denver County does a pretty good job. So the sheriff's auction occurs 110 to 125 days after the NED is filed. Obviously, that depends on if the debtor is challenging the foreclosure. It's a valid reason to do so, but typically that's the schedule. Agricultural properties are the exception to that. So in previous presentations, at this point I said I don't know what agricultural properties are, but I had a gentleman yesterday raise his hand and say it's 220 days instead of the 110 to 125. So 220 days for agricultural properties. The lender or the foreclosing property is required to submit their bid for the auction 2 days prior to the auction taking place. And that, again, that is public information, and you can pull that off of the county clerk and recorder's website or the public trustee's website in some cases. Good information to have. Typically the foreclosing party, their bid consists of the default amount. So whatever amount is in default, the balance of the loan, whatever costs they've incurred to proceed with the foreclosure, so attorney's fees, the public trustee fees, they add all of those in, and that is typically their bid amount. So it's a pretty standard equation that the lenders use for that. So assuming that the redemption periods run, and we'll talk a little bit more about that, then a confirmation deed is issued and the winning bidder owns the property. So that's kind of how the public trustee foreclosure process works. So the judicial foreclosure process, slightly different on the front end, but very similar on the tail end. So again, just like a normal lawsuit, except in the case of judicial foreclosures, you have to send a letter to the homeowner or the debtor who is in default. Let them know. Typically with lenders, it's either a notice of delinquency or a notice of acceleration. So most deeds of trust have acceleration clauses where if there's a default on the note, then the entire balance of the note gets accelerated and due immediately. So they'll send out a letter of acceleration letting the homeowner or the debtor know that they are in default. Then the complaint is filed in district court in whatever county the property is located. So that, again, that is public record. You can look those up. Service of process. So just like any lawsuit, if you've had any experience with litigation, the defendant or the debtor or the homeowner has to be served with the court documents. So a copy of the complaint and other exhibits that are relevant to the complaint. The lis pendens. So this is interesting. A lis pendens is basically just a notice that there is a pending lawsuit which the property is associated with. So a lis pendens is filed with the county clerk and recorder, and it's associated with a specific property. And so again, if anybody's going to buy a property, they do a title search, a lis pendens is going to pop up if there's a pending lawsuit where the property is involved, which of course foreclosures, the property is very much involved. And those, again, are recorded with the county clerk and recorders. And typically what happens with that, and the whole purpose, is during the foreclosure, the foreclosing party, the lender doesn't want the debtor to unload that property prior to the foreclosure coming to the conclusion. So the lis pendens puts everybody on notice that there's a pending lawsuit, and title companies will not insure over for a lis pendens. So then there's the judgment and decree. So in typical lawsuit fashion, both sides get to argue their facts, and then the judge makes a decision, issues a decree, and then after that, it's pretty much just like the public trustee foreclosure process. So there's a combined notice, there's the sheriff sale, published again. The redemption periods are exactly the same, and then at the end of the redemption periods, a confirmation deed is issued for whoever wins the bid at the auction. So opportunities for investors in the foreclosure process. So first of all, the first opportunity is, or where to find the opportunities. Again, public trustee websites typically list the NEDs that have been filed. County clerk and recorders have the bid amounts if once the foreclosing property has submitted the bids. Again, keep in mind that's 2 days prior to the auction. So if you're looking at this, you got to be prepared to move fast. Local publications for the combined notice. Again, 5 consecutive weeks is the publication period there. And then the county sheriff's websites typically have a list of properties and the schedule of the auctions. So here's the slide I thought I was on, the last one. So the first opportunity is to purchase the property prior to foreclosure. So this involves contacting the homeowner, discussing with them their situation, and seeing if there's a possibility of you purchasing the property prior to auction. So this is a really touchy subject with most homeowners because they already know there's a pending foreclosure. So they're kind of on hyper alert, looking for people trying to swoop in and get their property for much less than it's worth. Good thing about this is financing is still an option. It's more like a traditional purchase. So you can get financing, you can get title insurance, and you can get the inspections as well. So keep in mind though, the homeowner has the option to cure the default on the loan all the way up to 24 hours prior to the auction. So that's kind of the time period that you have to work with. Because once you see that NED filed, you can go in, talk to the homeowner, see what their situation is, see if they're open to some sort of a solution. But 1 day before the auction, they have the right, if they can come up with a rich uncle who can pay the loan for them, they can cure that default and retain possession of the home. So the second option is to purchase the property at the foreclosure auction. So much different than a traditional purchase. Funding has to be arranged ahead of time. So typically, I actually said in a previous presentation that some counties will give you, I think it's like 2 to 3 hours after you win the auction to go get funding. Roger corrected me and said most of them, actually you have to show up with a cashier's check. So you have to have the funds in hand prior to bidding on these properties, so that if you win, you turn over the check and go from there.
Cash is king.
Cash is king, exactly. So, different from a traditional purchase. You're not going to get title insurance because the title is still up in the air because of the foreclosure. No inspections. It's going to be an as-is purchase. Whatever inspections you can do as a drive-by. That's part of the homework that I have in a subsequent slide here, but definitely do your homework. Do an inspection, but there's not going to be any contingencies for inspections in the contract. I also heard from people that there's a lot of competition these days. So 2008 to 2010, in certain areas of the country, Nevada, Arizona, Florida, you could show up at these auctions and maybe there's 1 or 2 other investors there. Not really the case anymore. I've heard from folks that there can be 5 to 15 investors, depending on the property. And obviously the good properties get more interest. And you're competing with the lenders. Some of these lenders actually want the property in foreclosure. So and they do have the opportunity to keep on bidding their initial bid amount. They're not necessarily stuck with that. If the bidding goes up at the auction, the lender can keep on bidding as well.
Is it an open verbal auction or a closed bid?
I think most of them are open verbal. Some of them are actually online now. So, and I don't know which counties are online, but I do know that some are online.
I was under the impression that the lender could only go to the amount that they were owed, or something similar to that.
They do have the opportunity to increase their bid if they really want the property.
Okay.
Most of them don't. Most of them don't. They just, whatever their bid amount is, they're good with that. As long as they get paid, then they're fine. So the third opportunity is to purchase the property after foreclosure. So with all of these documents being published, you should know who the foreclosing party is. You should know who their attorney is, and you can actually contact them.
How long is the redemption period in Colorado?
8 days.
8 days.
Yeah, we'll talk about that here in a little bit. Unless you want to.
Yeah, the follow-up question was, can the homeowner purchase back the property during the redemption period in Colorado?
No. So what Colorado does is the homeowner has the cure period ahead of the auction. After that, they're out. Now they can, if they get some sort of an investment or somebody else comes in, then they can bid in the auction, but it's not really a right of redemption.
Isn't it supposed to be arm's length for them? I mean, like they're not, it can't go back to them?
Yeah, there would have to be some sort of a change in hands of ownership for them to come back into the process. But yeah, once their right to cure is up prior to the auction, then they're pretty much out. So we'll talk about a certificate of purchase, or the COP, but you can actually purchase. So a certificate of purchase is a right to own the property if the process goes through. Those can actually be purchased prior to the redemption period running, so that's an opportunity. You can usually get financing for these types of transactions with the lender. If it goes too much past the auction, though, and you're not in direct contact with them during the foreclosure process, then it's probably going to end up on the open market. And, typically what I've seen, and especially now that the market is strong, lenders really aren't giving any good deals after they purchase these properties. And in fact, sometimes they're not even really realistic. They'll have a property that's been vacant for 6 to 12 months, really run down, maybe some vandalism, and they have it listed market price, and you go in and try to deal with them, and they go, I'll give you $10,000 off, right? So just be aware of that. And typically these are as-is purchases with the lender. So some of the crucial considerations, one of the main ones is the Colorado Foreclosure Protection Act. So this is something that you should all be aware of, because there's a definition of equity purchaser in that statute, and anyone who's purchasing property in a foreclosure or even prior to foreclosure is going to fall within that definition, and so you have to comply with this statute. This statute has some pretty onerous requirements, notice requirements, specific language for cancellation. Has to be a written contract, and then the contract can be canceled for any reason within 3 days after execution. So if you get a contract in front of the home buyer, come to an agreement, they sign, they can call you up 3 days later and say, I'm out, and for no reason, right? And you just have to accept that. A lot of prohibited actions, and again, what they're trying to do is prevent homeowners from being taken advantage of. And then unconscionability. So this is one to kind of look out for. Unconscionability is usually if there's bad faith or some sort of deceit involved in the transaction. The contracts need to be translated into the primary language of the homeowner. So if you are aware that English is not their first language, then you're required to put that contract in their language. So unconscionability, one example of that would be, you know their primary language is Spanish, they're not very good with English, you put an English contract in front of them and say, sign, 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 you could fall into the unconscionability clause there.
What are notice requirements?
So, I don't know specifically what they are, but the law is CRS 6-1-1101. If you want some reading, if you're having a hard time sleeping. So, more crucial considerations. So I'm going to assume that you were the winning bid in the foreclosure auction. You want the property, you want to get the confirmation bidder, do you get the deed right then and there? The answer is no. What you get is a certificate of purchase, which gives you the opportunity to have ownership of the property once all of the redemption periods run. So, redemption, and I'm going to caveat this to the people who were at my previous presentations. I corrected myself for this one, so this one might be a little different than the one you heard. So the right of redemption. So after the auction takes place, the highest bidder has the certificate of purchase. Any junior lien holders, so lien holders that are in a junior position to the one that's being foreclosed, have the opportunity to redeem. So they can actually come in, submit a notice of redemption within 8 days after the auction, and the dollar amount that they typically redeem is whoever won the auction is they have the amount that they bid plus interest and any associated cost that they have associated with it. So the idea is that you're compensating the party that won the bid, but these junior lien holders, and it's in order of their superiority. So for example, yes?
But those junior lien holders, you can actually negotiate that price with them, correct?
Yes, absolutely, absolutely. So there's a couple ways around that. One, you can actually negotiate the price. They can accept less than what they're owed, or you can pay them off. The other thing you can do is you can get a power of attorney from the homeowner and actually go to all of the junior lien holders and pay them off. So there was a litigation not too long ago where the party who won the auction sent checks to all of the junior lien holders to preempt any redemption. And one of the junior lien holders actually wanted to come in and redeem and take the property, so they refused the check. Court said, no, you can't do that. If you get a check to pay off your lien, then you have to take it. So notice does not have to go out to junior lien holders. So whoever's foreclosing, if you're the first mortgage, second mortgage, all you have to do is give notice to any superior lien holders. The junior lien holders don't have to have notice. So, depending on who those people are, if they're not paying attention to the county clerk and recorder, to all of these documents being filed, or any liens on the property, then they may not know about it, and they may not even show up.
So once it's done, they can't do anything about it?
After the redemption period runs, then they are foreclosed out, so those debts go away.
Okay.
So is it typical, if you got the certificate of purchase, do you attempt to find the junior lien holders, or you wait and see if they show up?
I would wait and see if they show up, right?
You don't wanna
Don't
find
poke
them.
the sleeping bear, right?
What's their requirement to notify you?
Oh yeah, you have to know,
I
right?
mean, what's their requirement?
So they have to notify the public trustee or the court, depending on what type
Who then
of.
tells us they show up?
Exactly, and then the party that won the bid gets the notice saying, hey, submit your certificate of redemption. You give them the dollar amount saying, here's my bid, here's my extra costs, here's what I need to be redeemed.
To the junior lien.
To the junior lien. But, and this is the difference in my presentation, the junior lien holders actually take possession of the property if they redeem. So, and it goes in order of the lien. So if the first mortgage is being foreclosed, then the second mortgage would have the first opportunity to redeem. If they refuse or they don't show up, then it just goes on down the line. The other thing to keep in mind here is after you win, is your purchase is subject to the superior loans. So for example, the foreclosing property is, say, number 3 in line. They're the ones that are foreclosing. The superior liens are not foreclosed out. So whoever wins that bid, they take ownership subject to the superior liens, and those have to be paid off. HOAs have the opportunity to foreclose, and their interests are always superior to everything else except for the first mortgage. The caveat there is HOAs actually have what's called a super priority up to the amount of 6 months worth of regular assessments. Getting a lot of blank stares. So, let me explain that. So, assume that your regular monthly assessment for the HOA is $200 a month. right? 6 months worth, 6 months worth of that is $1,200. So in the amount of $1,200, if there's an HOA lien on the property for assessments, they have a super priority and they recover before anybody else up to the amount of $1,200. Below that amount, they still have not a super priority, but a priority where they're always second in line to the primary deed of trust.
So they're above the juniors.
They're above all the other juniors.
Okay,
They're the first junior.
okay, gotcha.
So, yes.
So there's been times when I was negotiating with HOA that I think they were owed like $30,000 or $40,000, and they were acting like they had a really strong hold on everything, and I needed them to go down to like $20,000 to get it to go.
Yeah.
And they said that they would have preferred to go to foreclosure, and it was the exact same thing. They were going to get like $1,200 or $1,300 if they got foreclosed on, as I understood it, rather than 20 that I was offering or the 40 that they were owed. Is that accurate, or?
That's fairly accurate. I mean, the only thing I'll say there is it depends on who is foreclosing, right? If there's a junior lien that was foreclosing, then obviously they're going to be in a superior position, right? And they're going to get the whole amount paid off. So maybe that's why
It was
they were
the
holding
first
strong.
mortgage in this case.
Oh, okay.
Yeah.
So what was their, why wouldn't they take your deal then?
I really don't understand why they didn't take it. I mean, they were paying attorney's fees, they were paying all of this stuff, and I'm not an attorney, but as I understood it, I thought they were only gonna be getting like $1,200.
So it's $1,200 plus their costs. So attorney's fees are included in that.
Okay.
So maybe their attorney's fees were
Okay.
astronomical. And that's what they were trying to recover.
Because it was actually the attorney that was arguing with me, so.
Okay.
There you go.
There you go.
If you think about it, where the HOA
Call me
takes
tomorrow.
a second, something like that, and the first lien holder is foreclosing, they do the redemption on it, if there's value in that, the HOA could stand to then purchase it, relist it, and make money on it.
Exactly.
If they foreclosed themselves and took over.
No, they wouldn't have to, if they're.
If if the first mortgage forecloses, gets the certificate of purchase, the HOA could come in and redeem.
Redeem by giving them all the money for the
Right.
total.
Right.
Well,
But
just.
if there's a lot of equity in the property,
Right.
then they can recover what they have in here.
So they don't need to start a foreclosure process.
No.
They can just step in and take the deal.
They redeem.
They redeem it.
They redeem
Yeah,
by paying up whatever the certificate of purchase is.
exactly.
Quick question. So it sounds like if no junior liens except HOAs can redeem above a second, it almost would make the most sense to target second lien holders and buy the redemption rights and redeem the property over any first. Because if they're always in that position to redeem, I mean, you could just target just them rather than trying to win it at auction if it's always going to be.
That's a
redeemable.
possibility. Yeah, absolutely. A lot of people do that. Yep.
So can you buy an HOA's junior lien? The super lien?
I have,
Yeah.
Yeah.
So, and what was the outcome?
that one, the guy ended up paying off, the homeowner caught on me after 4 years of never paying dues, but,
Correct me if I'm wrong here, though. I'm not sure the super priority. Stuff.
it's still gray area in certain areas.
Yeah.
Yeah, our attorney says gray areas, you don't go over cost.
Yeah, exactly. Yeah, the super priority may or may not go away.
But
That's
your
what's
best
happening.
bet would to let the HOA redeem it and then buy it from the HOA.
Unless they would just want to sell it.
Yeah.
I guess I'm in that right now. I'm on a board of a place for dealing with that.
Oh, okay.
I'm probably getting wrong information, but.
So the interesting case in Nevada involves the HOA. So before the statutes were in place, the various states said HOAs are having a hard time getting paid for these assessments. They gave them the super priority. So there was a case in Nevada where a party went in, an HOA went in, foreclosed. They were super priority over everyone, including the first deed of trust, and they foreclosed everybody out of the deal. So first mortgage went away, second mortgage went away, everybody was foreclosed out. And so literally they picked this property up for
$1,200.
Yeah, whatever their
Yeah.
late assessments were, right? And then that's when the states changed the statute that said, okay, you still have the super priority, but only up to the 6 months of regular assessments. So,
And above, and did you say below the first? Are they?
and they still have first priority of junior lien holders.
Got it.
But in a case like that, first still came out, no, what, first would pay for that.
No, the one in Nevada before the statute was in place for the limit on the super priority, the HOA had the super priority, they were ahead of everybody. They foreclosed, and everybody was foreclosed out.
And the first lien holder let that happen.
Well, they didn't know about it,
Okay.
right? Because they could have redeemed if they would have known about it, but they didn't. That was the other argument, that they didn't get proper notice. But
So is this like federal law versus state law?
no, it's state law.
It's state law, so
State law.
Nevada, so each state has to decide on the
Yeah.
priorities.
Yeah.
Okay.
Yeah, it's pretty standard across the states, but it's state specific. So the other thing to keep in mind here in your list of gotchas is homeowners don't always leave once the foreclosure process takes place, right? You win the bid, you get the redemption period runs, you get the confirmation deed, you call the homeowner and get, hey, the foreclosure's finished, here's the deed, give them a copy, and they don't leave. Happens all the time. So now you're in a situation where you have to evict them. So in some cases, and specifically to a judicial foreclosure, you can actually file a motion to get a court order for the eviction that's separate from a whole new FED. FED is a forced entry detainer. Yeah. So forced entry detainer is what you file with the court to get an eviction. And in most cases, it's a separate process. So I put this up here just because if you're buying these properties in foreclosure, that's something else that you're going to have to consider and work into your bid price, right? It may cost you something on the tail end to go through an eviction, and you may be looking at 30 to 60 days before that eviction takes place. So.
So the day of auction, are they not asked to leave, or what does that process look like?
So the day of auction, if they don't avail themselves of the right to cure, then they're completely out of the equation, right? So
But they're not forced to leave the day of auction.
no.
Okay.
So the
So-
new owner has
So
to deal with
yeah,
it.
it's
Yeah.
the new owner.
It's the new owner who has to take care of that.
Interesting. Okay. And
Yeah.
then the possessions on the inside, it's up to the new owner whether or not.
Well, that's standard eviction law, right? So if there's possessions in there, you know that they haven't vacated, then you have a duty to prevent damage to those possessions. If you get a writ of restitution and you show up with a sheriff and you move their possessions out on the street, you can do that. So, strategies for success. Number one is do your homework. Pay attention to the public publications of the NEDs, the combined notices. Get an O&E report on these properties so that, because again, on the combined notices, the junior lien holders won't necessarily be listed. So there could be other liens hanging out there that you don't know about that won't show up on any of these court documents or the public trustee documents. You're going to want to know that. You're going to want to know what the possibility of redemption looks like on the tail end of this. So get an O&E report, get a complete list of everybody who has liens or encumbrances on the property, and that way you know your risk on the redemption side. Physically look at the properties. Obviously don't trespass, but drive by, see what kind of shape it's in. Is it still occupied? Is it not? Do a bankruptcy search. So pacer.gov is a good location to do bankruptcy searches in specific district courts. So you can hop on that website. And I believe they charge you like 10 cents a page, but if you don't go over $5 in a month, then it's no charge.
What are you looking for on that bankruptcy search?
So what you're looking for in the that's a good question. What you're looking for in the bankruptcy search is if the homeowner has filed bankruptcy after the NED has been filed but prior to auction.
But
Right?
then the auction went through?
Well, no, because if they filed a bankruptcy prior to the auction,
Yeah.
then that puts the whole foreclosure process on ice,
Got it.
right? It's gonna wait for the bankruptcy process to go through, and then the foreclosure may or may not resume.
Even 1 day before the auction?
Yes, even 1 day before the auction. Talk to the homeowner. So again, this works better prior to the foreclosure or the auction taking place, because they don't really have any leverage after the auction. But talk to the homeowner, see what their situation is, if they're open to some sort of an arrangement. Talk to the lender's attorney. So the lender's attorney is going to be listed on all of the court documents or the public trustee documents. Feel free to give them a call. I actually know somebody who's a foreclosure attorney who does nothing but represents homeowners in foreclosures. Those people are actually really good sources of information, because there are times where the attorney will take the case of a homeowner, look at the entire situation, and tell the homeowner, your best bet is to sell this property somehow, right? And there may be limitations of doing it on the open market, and there may be other liens outstanding, right? But I had one foreclosure attorney tell me that they actually have investors on speed dial that they'll call up and go, hey, I have this situation, you might be able to help the homeowner out. Because in certain cases, it's still in the best interest of the homeowner to make that happen. That's all I have.